All right, this is the 100-120 class. This is some jury charge warm-up for the record. Ladies and gentlemen of the jury, today I am going to address you and talk to you about the law that you must apply during the course of your deliberations. As has been said before, and I will say it to you one more time to make it legal and official, when it comes to what the facts are in this case and what happened at the Bluebell Inn on the evening of November 8, 2011, if anything did happen out there, this is for you to decide. You decide what happened, who did what, who was there, and what are the facts that you want to believe. You are the judges of the facts in this case. Your judgment is important in deciding what the facts are that are to be believed. You are the sole and exclusive judges of the facts. Ask yourself what took place at the Bluebell Inn. Ask yourself questions about the case, just as the lawyers have asked each of the witnesses questions about the case. What we lawyers say is not what happened. It is not what each individual witness said happened. It is what you decide happened based upon the evidence in reaching your conclusions. The lawyers in their summations talked at length about the testimony. Now, during the course of my jury charge, I will talk about the testimony as given by the witnesses. Ladies and gentlemen of the jury, in reaching your decision as to what happened at the Bluebell Inn, you have to rely on your own recollection of what the testimony was that was given. Your recollection of that testimony is the most important part of this trial. I will assure you at this time, if I state some small portion of testimony and it differs from what you recall, you must rely on your own recollections. I assure you that none of us here in the courtroom, the attorneys, or anyone else are deliberately trying to mislead you or attempt to mislead you by misstating what the evidence was. We may by accident misstate it, but it is not a deliberate act on our parts. You must rely on your own recollection, ladies and gentlemen of the jury, of what the testimony was. One of your main and important functions is to decide who you believe. You must decide what you believe. You must decide which witnesses you believe, and then in arriving at that decision, as far as which witness to believe and what part of their testimony to believe, you should use your common sense and sound judgment that you use in your daily lives to make your decision. In life, we are all called upon to make decisions. We must decide whether or not to believe a story that someone told us. You must make that decision on a daily basis. Well, use your same common sense here, your same judgment that you use in your everyday life to determine which witnesses you believe and what portion of their testimony you are going to believe. You may believe all of their testimony, none of it, or some of it. During the course of the trial, you had the opportunity to see and hear the witnesses while they were on the stand. You watched them testify. The credibility of a witness has to be determined by you. You must evaluate the witness's demeanor while testifying, their mannerisms while testifying, and how they responded to the questions asked of them. Did you notice that the witness hesitated on certain questions? Did the witness try to evade answering a question? Was the witness reluctant at any time to offer an answer? Were the answers direct and to the point? You may also consider along these lines the credibility of each of the witnesses. You must evaluate whether or not a witness was interested in the outcome of this trial. Did they have a personal interest or a personal gain in the outcome of the trial? If they did, this might cause a witness to testify in less than an accurate manner. If you find that any witness did have an interest in the outcome of the trial, that witness is not necessarily entitled to less credit than another witness who has no interest in the outcome of the trial. And you may find that anyone who did stand to lose or gain by the way they testified in this trial, you may consider that in assigning weight to individual testimony. Ladies and gentlemen of the jury, during your deliberations, it must be the quality of the testimony that should guide you and not the actual quantity. You cannot say that the side with 35 witnesses had more believability than the side with 4 witnesses. That should not enter your mind. You should be only interested in the quality of the testimony. This will be some literary material for the record. I want to thank Nancy and Lori and the other students who showed me around this fine place and showed me what they do here. I thank you for that. What we are doing here today to celebrate the 1-year anniversary of the School to Work program is really adapting to the information age in the 21st century, one of the oldest traditions in the United States. Just imagine, for example, here we are in Maryland. What if we were here 200 years ago? Would you be a young person living in a settlement in Maryland called Port Tobacco, which was then a big town around these parts? You'd be in a promising new country. George Washington would be your president. John Adams would be your vice president. Pretty good lineup. And everybody would be optimistic, and most people would be like Nancy. They'd get up at 5 a.m. or 5:30 a.m. every day, ready to go to work. If you wanted a better job, you'd probably leave the country and come into town, where you would walk down a main street and you would look at the people who were working. 200 years ago, you'd see a blacksmith, a carpenter, and of course, a printer. If you wanted to learn how to do those jobs, you'd simply knock on one of the doors and hope that in return for hard work, you could get a craftsman to teach you those skills. That's the way it was done 200 years ago. And for a long time, that's the way it was done, as one generation kept faith with the next. Well, we know that we can't exactly do it that way anymore. But if you think about it, that's what the School to Work program is all about in modern terms for the modern economy. And it's very, very important. This year, we are seeing grants that involve over 100,000 students nationwide, over 40,000 employers, including very large and very powerful employers in this country, but also some very, very small ones. And there are over 2,500 schools all across America involved in this program. The act was a genuine partnership. It set up no bureaucracy, whatever. It simply made grants to local partnerships, many of them in poor areas, and gave students the chance to show what their hard work could do. This year, we are doubling the school to work funding for the 8 pioneer states that already have programs. Seed grants will go out to 20 new states so that all 50 states will have some participation in the school to work program. By 1997, every state in America will have a school to work program up and running. One thing that I want to emphasize is that very important is that the school to work program rests on a few very big ideas. One of the ones that's most important to me is that there is no choice to be made between practical workplace skills and academic knowledge, that the two reinforce each other and go hand in hand. When I was growing up, there was always this bright line between what was a vocational or practical skill and what was an academic skill. It was probably a mistake then. It is certainly a mistake now. We have to abolish that line.